SA21 is now in session.
Please be seated. We're here in case 1 SA21-0170, Arizona Petition Partners versus Thompson. Each side will have 20 minutes to present their argument. Petitioner, you may save as much time as you want for rebuttal, but you'll have to keep track of your own time. Although you're arguing at your table, we have the clock at the main podium. Feel free to walk around so you can see the clock if necessary. We are recording the argument both in audio and video. When it's your turn, please identify yourself and your client so that when we review the argument, we can keep everybody straight. The video will be on YouTube in a few days if you want to see how well you did. We've read the briefs and conference the case. We're familiar with the facts and the issues and the law. So when you begin your argument, just start right out with what you'd like to talk with us about. Counsel, you may begin.
Thank you. Good morning. My name is Kathy Brody. I'm here with my co-counsel Lee Stein and Ann Chapman on behalf of Petition Partners, and Andrew Chavez of Petition Partners is here with us also today. And may it please the court. This case calls for a straightforward application of Malera v. Hobbs and also Preet versus Bradbury. Those cases require this court to conclude that ARS section 19-11801 bans only per signature payments to initiative circulators.
So are you making the argument that your conduct doesn't meet the statutory definition as seen through Malera, or are you making a broader argument that regardless of the facts, that the statute is unconstitutional?
Yeah, so, Your Honor, we are arguing that the facts as alleged by the state do not violate the statute because the statute bans only per signature payments to initiative circulators, and the alleged conduct, it does not constitute per signature payments to initiative circulators. And I think...
So you're not making the argument that regardless of the facts, the statute is unconstitutional?
Our primary argument, Your Honor, and the basis that we think the court should decide this case is on the basis of statutory interpretation under Majak and similar to Vo versus Superior Court. Mm-hmm. And we think that that is not, it's the correct resolution of this case, but it's also the resolution of this case that doesn't require the court to get into the constitutional issues if it does not want to reach those. And really,
and do we have the facts to be able to make the determination of whether the conduct at issue here, whether the programs at issue meet the statute or they don't? Isn't that more, shouldn't this all be worked out in the trial court before it comes here?
We don't agree with that, Your Honor. This case is similar on all fours with the posture in both Majak and Vo versus Superior Court. In both of those cases, Vo, the Court of Appeals, and then Majak, the Arizona Supreme Court, what they did is they interpreted the statute to determine whether the alleged conduct violates the statute.
Counsel, let's maybe from a different perspective. What if we disagree with your reading of Malera? Then what? What if we flat out disagree that Malera is only a per signature, imposed only a per signature ban? Then where do you go with your argument?
Right. So if the court is inclined to, we think that Malera clearly says that the statute bans only per signature payments. We think that the only...
What about in light of paragraph 35?
Right.
That says it's compensation based in whole or in part.
Yes, Your Honor. And let me talk about that, because I agree that that's important. Now, what we think the Supreme Court means there, and what we think is the only thing the Supreme Court can mean there, consistent with the other authorities, is that in whole means that a circulator's entire compensation is per signature compensation. For instance, you will be compensated $1 per signature collected. Now, in part means that only a portion of the circulator's entire compensation is per signature. So, for instance, you can get paid $15 an hour plus 50 cents per signature. Or another example would be you get a $20 bonus if you collect 50 signatures. And that, in part, what I would point the court to is to look at the Independence Institute v. Gessler case, where the statute at issue there was that the person couldn't get paid more than 20% of their pay per signature. And so that's how we read in part in the court's decision. And I think a couple of important points about what a per signature payment is and why the conduct alleged is not per signature payments. Unless I have another question from Your Honor. You look like you have another question.
Okay, so,
yeah.
I mean, I'm just really struggling with the idea that our Supreme Court went through paragraphs and paragraphs of analysis. If they thought it was a per signature ban, they would have just said that, because they cited the legislative history and they pointed out that the sponsor of the bill said it's a per signature ban. That's all it is. Why didn't the Supreme Court just stop right there? I mean, what is the need to go on and flesh out and get into sort of machinations about, or ruminations of what this statute really means? I think you're asking us to just take like 15 words, or whatever, how many words in each count of 50 counts, and assume those, even assuming the truth of those, and just say, as a matter of law, it doesn't violate the statute. I don't see how we get there.
Mm-hmm. Well, let me talk about Preet versus Bradbury and the legislative intent a little, because I think really what we need to do is understand what the legislative intent behind the statute is, and we know that
but let's stop right there. Okay. I mean, isn't the cardinal rule of statutory interpretation? We don't go to legislative history. We go right to the plain language. But are we really writing on a clean slate here? Aren't we bound by every word from upstairs?
Yes, we agree 100% with that, Your Honor, that this court is bound by what the Supreme Court said in Malera. And we believe that reading the opinion altogether, that is the only conclusion that and I would say the reason that the court did not flat out say this bans only per signature payments is that the court didn't have to reach that question, because it was able to interpret the statute. It didn't have to reach that question. Now, your question about statutory interpretation, Your Honor, I think that's an important question, because one of the most important things, I think, for resolution of this case that the Arizona Supreme Court said in Malera is that this statute, and particularly the term based on, is susceptible to more than one reasonable meaning.
Well, yeah, I probably disagree with that. To me, it's debatable whether they said that, but go ahead, assume that they did. I mean, they cited the law, but I don't know if they said one way or the other whether it was ambiguous or not. But I think before time gets away too fast, I'd like to shift to the constitutionality, if you don't mind, because what is the correct standard of review? Keeping in mind that this is a criminal prosecution, is the Anderson-Timmer framework, if I got those cases correctly, is that what we should be applying, or should we be applying straight up strict scrutiny here?
So, Your Honor, if the court does decide to analyze this case under the Anderson verdict framework with Meyer in mind, as we said in our supplemental brief, that is, the court has said that it's a sliding scale depending on the size of the burden. And for some of the reasons Your Honor recognized, we think that this law imposes a significant burden on speech, particularly if it is read to ban more than per signature payments. If it's read to ban more than per signature payments, the case law is pretty clear that banning payments based on productivity renders something a significant burden. And in addition, of course, we have the fact that it's a criminal statute. We have a fact that it's written likely as a strict liability crime. And so we do believe that strict scrutiny applies because this statute imposes a significant burden on speech.
What about the cases, the courts that have upheld statutes that did have a criminal component? I can't point to exactly. North Dakota, I'm thinking, maybe Montana. Those courts did not seem to have a problem with the criminality of the statute, with very similar restrictions on payments to circulators. What's the problem with following those cases?
So we urge the court to follow those cases, and we think that those cases interpreted per signature bans on circulator compensation. If you look at Preet, that had a criminal component as well. And that was interpreting it as a per signature ban. In Preet, the court in the first sentence calls it piecework or per signature. In Yeager, the court there, another one of those cases that Your Honor is referring to, that they call the payments commission payments there. And so what these cases are talking about is a per signature payment where a circulator gets paid a specific amount of money for a specified number of signatures. And so we do think that those authorities, as well as Preet and Malera, support our position, which is that those cases are about, and our statute in particular, is about per signature payments. And there are no per signature payments at issue here. Yes.
To return to your earlier argument, when you're asking us to interpret the statute, that presupposes that we know all the relevant facts and that there's no dispute as to the facts. Do the parties agree on them? At least at this stage, do the parties agree on what the facts are about the programs and how they factually operate for us to make the legal determination whether those facts fit the statute or not?
Right, so for purposes of the issues before this court, we do not dispute the allegations as alleged by the state. Now, we would contest those at trial, but we don't think our factual disputes matter for the purposes of this court's decision. And, I would just point, I look at page 11 of the state's brief to look at what the state is alleging that petition partners did in this case. And again, for purposes of these proceedings, just like the criminal defendant in the Majak case, and just like the criminal defendant in the Vo case, we're not contesting those factual allegations for the purposes of these issues before the court. If there are no other questions, I will reserve the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Lindley Wilson for the Arizona Attorney General's Office, along with my co-counsel Todd Lawson, representing the state of Arizona. I think I'll start by perhaps addressing the MEJAC question about the first motion to dismiss regarding the legal sufficiency of the state's information. I don't think that issue warrants discretionary jurisdiction in a special action proceeding because this is not like the MEJAC case. There, the crime was luring a minor for sexual exploitation, and the facts alleged by the state were that there was no minor, that the person lured was a reporter posing as a minor. And so the court looked simply to the statute, which said you have to lure a minor, and it's also not a defense if it was a peace officer posing as a minor. And even under the state's alleged facts, it didn't meet the statutory definition. Here, in contrast, the state has alleged that these two bonus programs were committed in violation of the statutory language, that these were payments based on the number of signatures collected on a statewide initiative.
But isn't that reading of the statute require, as counsel has pointed out, a broader construction of based on, which Malera tells us we can't do?
No, I think the operative language is that the signatures were collected and then a payment was made. And so I actually agree with opposing counsel that this case is straightforward based on Malera and Preet. Those cases dispose of the constitutional claims and the statutory interpretation claims because even Malera says at one point in the opinion, it upheld the spin the wheel program that was at issue and said the factual evidence actually turned out that anyone could spin the wheel for morale building incentives and programs. But in one part of Malera, the court expressly stated if the spin the wheel opportunity were contingent on the number of signatures collected, that would present a close question. And that is exactly why something like this should be really fleshed out at trial, and it doesn't warrant special action jurisdiction to say that the information is legally sufficient, because applying Malera, it clearly is. It's tracking the statutory language.
But counsel, isn't there a significant difference between saying this is prohibited and this is a closer question? I mean, the Supreme Court didn't come out and say, if they did this, then that would be absolutely prohibited.
Right.
Right?
I agree.
So, and we also have this concern that we have this narrower construction, because the Malera case clearly says that we are to apply a narrow construction to based on.
Right.
And yet, and correct me if I'm wrong, neither of these reward programs can be subjected to this kind of mathematically precise view where you divide the number of signatures that each circulator brought in and apply it to result in a particular amount of compensation that was paid to that particular circulator. Do you agree with that, or am I wrong on that?
If I understand you correctly, I think, and maybe this is sort of getting to some of the comments on the other side about whether this really operates as an overall cap on compensation. And that's where a district court in Colorado held in Gessler, that actually is more restrictive than Arizona's law, because signature gathering companies don't have the flexibility of designing other incentive programs if you have to do a mathematical calculation at the end of the day to decide if the total compensation violated the law. That was what was held to be problematic in Colorado. And I think it's important that on the topic of Gessler, that was following a 10-day trial on the question of whether that law imposed a severe burden on the actual plaintiff's constitutional rights, which required factual development. Even the Sixth Circuit case, Dieters, recognizes that this is a fact-intensive question. And I think all of those reasons are reasons that it's, and I wanted to clarify this in my supplemental brief, I don't think I made this entirely clear, but the Anderson-Burdick framework in a facial challenge does apply in conjunction with the Supreme Court cases like United States versus Williams, and Broderick versus Oklahoma. So, in other words, the petition partners has only alleged a facial challenge in their special action petition, and under prevailing law, they have a heavy burden of overcoming the presumption of constitutionality and showing that the law is on its face unconstitutional.
Counsel, are you aware of any case that involves these types of circumstances that actually evaluated the constitutionality of the statute, and in specifically which standard to apply in the context of a prosecution?
You know, this is a very fact-intensive claim, I think. I think all this case law, from the circuit case law that we've all cited as analogous authority, dealt with election challenges for the most part, or civil declaratory actions. And I think it's important that those are all as-applied challenges. So to a large extent, I don't think the court needs to reach a lot of these issues identified in the supplemental brief order because they're not really before the court yet. In Petition Partners' special action petition, footnote 43 expressly noted that they haven't asked for an evidentiary hearing on a straight-up First Amendment challenge as applied to them that this violates their constitutional rights.
Where I'm going here is that there is a facial challenge here, and in order to evaluate constitutionality, we have to understand under what framework we're evaluating the constitutionality.
Of course.
Okay, so is it the state's position then that Anderson applies the Anderson framework that has been applied in other cases which are of a civil nature, that's what you said, that's a one-to-one, apples-to-apples correlation to a criminal prosecution?
I don't think there's any reason that that the Anderson verdict framework wouldn't apply in a criminal prosecution per se. I haven't read any cases for that, standing for that proposition. I think the more nuanced question here is plaintiffs are raising a facial challenge to the constitutionality of a statute, and under cases like Broderick and Williams, step one is to construe the statute. Malera has already done that. Step two is to look at whether it still prohibits or criminalizes a substantial amount of protected speech. And we know based on this relevant circuit authority and on the limited prescription of the law at issue here that it doesn't. It only regulates at most conduct that is incidentally related to speech. And looking at cases like Arizonans for second chances versus Hobbs from our Supreme Court, there that was, again, an as-applied challenge. It was not a facial challenge to the statute, but the Arizona Supreme Court did an as-applied analysis to find that even the Arizona Constitution's in-person signature gathering requirements were not unconstitutional in light of COVID-19. So these are all these factual questions about the degree of the burden and the whether the states are important regulatory interests or compelling interests, I think need to be resolved at a later time when the Superior Court can actually hear evidence on all that.
But counsel, I think since Meyer, it's been recognized that the right to have paid circulators is a matter of core political speech. I believe that's the language that they use.
Meyer used that language in the context of a wholesale prohibition on paying circulators, period. And then, as our Supreme Court had noted in second chances, the later decision of Buckley versus ACLF significantly refined Meyer's analysis. So in other words, ACLF refined Meyer to say only restrictions that significantly inhibit speech rise to the level of Meyer. And I think it's paragraph 74, 75, where the Supreme Court collects cases distinguishing Meyer. But
that doesn't change the fact that having paid circulators implicates core political speech. That's my point.
I think it does change. In other words, the restriction was unconstitutional in Meyer because it was a far-reaching, broad restriction that directly implicated core political speech, again, in an as-applied context. So that even Meyer was not a facial challenge to the constitutionality of the law.
And if we're talking about burden, doesn't the deprivation, or at least the threatened deprivation of liberty, constitute a heavy burden?
I think that the legislature has criminalized these as misdemeanors and that that's generally understood as a low-level offense. And to the extent that I just haven't seen any authority for the proposition that simply because the legislature has chosen to criminalize something as a misdemeanor, that transforms it into an unconstitutional burden.
Yeah, but this isn't like, dog at large or jaywalking. This is a class 1 misdemeanor.
Like many other statutes in Title 19, Title 13, it's within the legislature's authority to prescribe crimes and their punishments. That's just classic separation of powers.
Right, but are you arguing that a potential 6 months in jail and thousands of dollars in fines is low level? That's not burdensome.
Those are the absolute maximums that could be imposed. Of course, probation is available. There's all of these things that are available under Title 13. But yes, I do think that if a court is second-guessing a legislature's judgment that something should be penalized as a misdemeanor crime, I don't think that that doesn't state a constitutional claim.
Well, what about the burden on for an enterprise on petition partners? I mean, if I understand the law correctly, the maximum, in theoretical maximum here is $5 million, not just $1 million as petition partners, because the statute says 5 times the maximum can be implemented if there's willful or wanton conduct. I'm really skeptical that there's willful or wanton conduct here, but how is that not a pretty significant burden on, the threat, just the threat?
For the same reasons that our Supreme Court said in State versus Sotofong in the context of an Eighth Amendment claim of cruel and unusual punishment, the fact that crimes might be stacked and look worse in the aggregate does not manufacture a constitutional claim. It's kind of the same principle.
But Sotofong didn't involve First Amendment rights. We're clearly talking about the threat of encroaching on people's First Amendment rights to affect change in society. I
think arguments or ideas about that are just purely speculative. If we look at the actual record that exists before this court in the special action proceeding, there's nothing to suggest that petition circulators are less willing to serve as circulators. The ultimate question, as we've argued in the supplemental brief, is whether the available pool of circulators has been significantly decreased as a result of the law. And so in this case, for example, in the opening brief to the Arizona Supreme Court, petition partners said that they spent less than 1/10% of their total payroll, something like $3.9 million, on the Dueling for Dollars program, which is 49 of the 50 counts here. So, and perhaps...
Well, so the threat of prison time and extremely heavy fine does not deter First Amendment activity?
No, there's nothing in the record to suggest that. We've cited the circuit case law that says you can't just speculate that something might impose a burden to find a law facially unconstitutional.
But that's under the Anderson verdict framework. What if that doesn't apply in criminal prosecution cases? Because there's no case that I've found that says it does, that it should or does apply in a criminal prosecution case.
I'd first just point out that even in Arizonans for Second Chances, our Supreme Court broadly said that a challenge to an election-related regulation is reviewed under the Anderson verdict framework. Granted, they were only considering an as-applied argument and not a facial challenge, but I think that there's still no basis in which to assume or speculate that the fact that this is punished as a misdemeanor somehow impermissibly infringes on First Amendment protected activity.
But if strict scrutiny did apply here, would the state has the state met its burden of showing a compelling interest?
I think it would. Again, Arizonans for Second Chances clearly says that it is a compelling interest for the legislature to protect the integrity of its initiative process. That's outlined in the Purity of Elections Clause in the Arizona Constitution. And I'm glad you asked about strict scrutiny because, again, the plaintiffs haven't requested a hearing on that question expressly, so I don't think that that's really before the court. But strict scrutiny is triggered only if the law limits the pool of available circulators. That is the narrow question in a claim like this.
But again, you're going back to the framework, right? That's what the framework says.
Sure.
Okay.
And then otherwise, if we're outside of the Anderson verdict framework, even looking at cases like United States versus Williams and Broderick versus Oklahoma, Williams, for example, was a facial challenge to the law, the federal law criminalizing solicitation of child pornography. So Broderick actually involved Oklahoma's Mini Hatch Act and political restrictions like that, but if Williams is maybe more applicable because that's a criminal issue about facial constitutionality of that statute, I think that that's very clear. Under Williams, the first step is to construe the statute. And again, everyone admits and acknowledges that Malera is binding on this court, and paragraph 35 resolves the statutory interpretation issue. Step 2 is whether the statute criminalizes a substantial amount of protected speech. And again, I think given the narrowing construction in Malera, the answer is still no. But if the court, another idea is that if the court thinks that the overbreadth facial challenge is too intertwined with disputed facts or maybe a record that hasn't been fleshed out yet, the court could simply decline special action jurisdiction on the overbreadth argument. The court has wide flexibility in these types of proceedings and doesn't have to accept jurisdiction in its discretion on all of the issues presented. I think that there's some utility in discussing the vagueness argument because, of course, the state doesn't think that it's vague, and because this law applies equally to petition circulators, it may be worth following the State versus Velos analysis of reading into the statute a knowing requirement, so that moving forward.
On that point, I understand. There's also the proposition that although we narrowly construe statutes, so that they are to uphold the constitutionality, we also don't rewrite statutes.
Right.
To uphold the constitutionality. So so it seems like a fine line there. Why would we sort of impute a mental state requirement when it appears that the legislature rejected that suggestion?
I think that there's a couple answers to that. First, I think the legislature would have been within its authority to prescribe a strict liability offense here, but ARS 13202B expressly allows courts to imply a mental state under certain circumstances, and I think Velos is the most applicable case there. That involved organized retail theft, and the court looked to other provisions in that chapter of Title 13 to decide what mental state necessarily applied to organized retail theft. And so I don't think that's a situation in which the court is rewriting the statute. It's merely saying that this offense necessarily implies a mental state, and this is the analysis we apply, which is discussed in Velos, and I think that's very applicable here.
One of the problems here is that we have essentially a civil statute here. It's civil. I mean, the substance, right? You would agree with me. It's a civil statute.
Well, subsection B criminalizes the violations.
I know, but that would be unlike Velos. It would be unlike. I mean, are you aware of situations where we've inferred the mental state requirement in a case where I don't think
it's case specific. It's offense specific, and this is not unlike what the court did in Velos. I think that was a 2015 decision where we're looking at a substantive crime codified. The fact that this is codified in Title 19, I don't think makes a difference. There are a host of other statutes in Title 19 regulating. This is a highly regulated area of the law. Petition circulators are subject to all sorts of requirements outlined in Title 19. And so that's also another reason that the fact that this law is criminalized, if there's some problem assumed with the legislature's authority in doing this, that would also put into question a host of other laws in Title 19 that the legislature had authority to enact. So in sum, I think Velos is the most applicable case that the court should look to on the strict liability. And it's also supported by the Nevada Supreme Court's decision in Busefink, which we cite in our supplemental brief. The Nevada Supreme Court interpreted a very similar law that prohibited payment based on the number of registrations obtained. So it's really no different from this statute. And the court upheld that against a vagueness challenge and reasoned that that type of law implies a knowing intent that would apply to the payment of workers based upon the number of voters registered.
Counsel, can you address just briefly the argument against attorney's fees again? If I understand the briefing, the position is that the state believes this arises pursuant to Title 13 because the enforcement structures are in 13. So then how do you respond to the explicit call out of Title 28 in the exception as well?
Well, I think it's more than just enforcement. This is where Title 13 provides where all of the sentencing and fines provisions are. So it's much more, I think the way to look at it is the only thing that's outside of Title 13 is the substantive offense in Title 19. So I think this is pursuant to Title 13.
That's a critical component. All the procedures and sentencing statutes and rules don't matter without the substantive law of criminalizing the conduct. So it would be odd to say that comes out of Title 13.
Well, I think the court's holding in State versus Shipman from the 2004 is pretty broad. The petition partners attempted to distinguish it in one sentence by saying that this case is off point because that involved a prosecution under Title 28. But this court interpreted Rule 11, Rule 4, and did so inconsistent with the statute, and broadly held because long established Arizona statute expressly excludes criminal cases from its provisions authorizing fees against the state. We conclude Rule 4G was not intended to authorize the grant of fees or costs in special actions arising from criminal proceedings. And so the state didn't bring this special action below. This is a special action arising from a criminal proceeding. So I think if you were to find that attorney's fees are appropriate on either side of this case, you would have to overrule State versus Shipman, which also relies on an Arizona Supreme Court case. So I think there's a lot more, and if the court wants supplemental briefing, we'd be happy to do that on attorney's fees. But I think it would require overruling quite a bit of precedent interpreting the statute and applicable rules.
Thank you, counsel.
I see that I'm out of time.
We appreciate your argument, counsel.
Thank you.
Yes, thank you. I think the first step that this court has to take in whatever decision it makes is interpreting the statute. We have to know what the statute means, what it prohibits, before the court can decide whether it's constitutional. And that's, for instance, what the Alaska Supreme Court did in Vote Yes, right? You have to decide what does the statute mean, what does it prohibit, what does it not prohibit. And even in Preet, and this is at page 971 in Preet, the court says that you have to evaluate whether the chosen method is reasonably related to the regulatory interest. So not only do we need to know, does this statute ban per signature payments or something more in order to determine the constitutionality, but in fact, we need to know that in order, if we have to go to trial under this statute, we need to know in advance what it bans and what it doesn't ban.
Counsel, I think, at least the way I've been looking at this case, the operative definition based on is in paragraph 35 of Malvera. Can you give, I realize the time, can you give a brief explanation of how the programs don't fit that definition?
Right. Our view of what based on means is per signature.
Well,
and we think that that's what the court's saying.
The language that they use is if the compensation is paid to the stipulator for collecting signatures is dependent on or calculated by in whole or in part the number of signatures collected during the compensation period. That's in the middle of paragraph 35. To me, that is the definition of based on, which arguably is broader than your argument that is per signature.
Yes.
How much broader is up for debate, but it seems at least moderately broader than your argument. And I guess what I'm looking for is, given that definition, how do your programs not fit that? Don't fit that
I think I understand. So first of all, I would like to say, I think possibly the most important word in that paragraph 35 is the word specified at the end of the paragraph. And what that means is what Judge Ferruia was saying a little bit earlier, that it means that something can be calculated in a mathematical way. And so that's what based on means. that it is a specified number that can be calculated, $1 per signature, $5 per 20 signatures. And so that's what we think the court is saying there.
So how do the programs
Right.
operate?
And so what the state is alleging is that Weekend Warriors was a bonus that took into account the total number of hours that a circulator worked in the week. It took into account how many hours they worked on the weekend, and it took into account whether they had collected at least 3 sets of signatures per hour. So it's to be eligible for the bonus, you had to collect a certain number of signature sets per hour in addition to other productivity criteria. Dueling for dollars, the state is alleging that there was a bonus paid to a circulator who collected more signatures than another circulator. And so neither of those bonuses, as alleged by the state, involves a direct correlation, a mathematical calculation between the specific or specified number of signatures and the amount of the payment. And that's how we read that. And before I sit down, I do want to make sure that I am clear about why Malera forecloses this prosecution and forecloses the state's reading of the statute. First, Malera, and this is all in paragraph 39 of Malera, Malera confirms that the legislature intended to model our law after the Oregon law upheld in Preet so that the law would be constitutional. And that law reads in not just the language of the statute, but the explicit interpretation of that in Preet by the administrative rule. Malera also confirms that the legislature was focused on banning per signature payments only. It also confirms that the legislature intended the term based on to have a narrow application. That's all in paragraph 39. Now, second, Malera explicitly rejected a reading of the statute that would ban rewarding circulators for past productivity. That's in paragraph 36. And the court notes in paragraph 37, this is quoting Dieters, that such a ban would probably be unconstitutional because it would be a significant burden on speech. Now, third, Malera rejected a broad reading of the statute and also the term based on because the court recognized that businesses have to be able to account for productivity in their normal business operations. Petition partners, the business operation is collecting hundreds of thousands of signatures to qualify for the initiative measure. That's a big operation. As a matter of electoral calendars, that a lot of that happens over the summer. And the business needs the flexibility, as recognized by Malera, to incentivize and reward circulators to keep them going through those tough times. That's paragraph 40 of Malera. And I would just say, finally, and this is important, we've been talking about this a lot. Malera confirms that no other court in the country has approved a regulation on circulator compensation that is more restrictive than a per signature ban. That's in paragraph 37 of Malera, where the court says, and this is a quote, courts in other jurisdictions have upheld bans on per signature compensation for circulators. And the court is citing Preet and Yeager and Person.
But that's not necessarily saying you can't be more restrictive. The court's not saying that at all, are they?
The point is, Your Honor, that no other court in the country has approved a restriction on circulator pay
Understood.
that's more restricted, and that's what the Supreme Court is saying. Yeah.
I'd like you to turn to paragraph 53 briefly.
Yes. Yeah.
The second sentence says, as the court is concluding here, the court correctly disqualified only signatures collected by circulators during the pay periods in which they were paid bonuses that violated section 19118.01a. What's your interpretation of that sentence? I read it as at least some evidence that the court found that there were bonuses that were paid that violated the statute. Which bonuses would those have been?
Your Honor, that actually is a good question. I would say the state and we seem to agree now that the court did not rule on the legality of these particular programs at issue.
Well, at least you wanted to justify our order slightly, because I think you'd agree with me that's at least slightly ambiguous as to why the court said that, because that's what led to our supplemental briefing order when it's it definitely suggests that there was a violation of some bonus program of the statute. So I just wanted to
Yeah,
get your take on that.
That's, and I would say, the best take I have on that, Your Honor, is that the state, based on, their papers, and this is in their response to our Majack motion below, the state apparently believed that the court was, at that time at least, that the court was saying that these programs violated the statute because the state initiated this
Well, sure,
prosecution.
they filed the
based on this.
charges, yeah.
But they changed their mind, and they no longer believe that that's what that says. And, we do think that Malera forecloses this argument. We do think that interpreting this beyond banning per signature payments would be a departure from the other authorities that we've cited. And we think that Malera binds the court to conclude that that the statute bans per signature payments only.
Thank you, counsel. We appreciate both your arguments. Today, we will take this matter under advisement and will issue a decision in due course. We stand adjourned.